political system denotes a situation in which the chief executive imposes restrictions on the right to freedom of people. In India, such restrictions are imposed according to certain provisions enshrined in the Constitution, generally known as emergency provisions. Emergency is imposed under some situations such as war, external aggression, internal disturbances or armed rebellion or financial crisis in whole of India or any part of it. It imposes restrictions on freedom of people. Emergency provisions in Indian Constitution are provided in a separate Part 18 under Articles 352 to 360. The order to declare emergency is passed by the President of India. He declares it on the advice of Council of Ministers. However, the real power during emergency is exercised by the Prime Minister. During emergency, the Union Executive can give directions to the Executive in the states and the Parliament can pass legislation on any matter which is not in the Union Legislature list. During emergency, authorities of the state government enjoy subordinate positions to the central authorities. Indian Constitution followed Government of India Act 1935, which embodied emergency provisions in Section 45 for the centre and in Section 93 for the provinces. It empowered the Chief Executive to declare emergency. The Government of India Act 1935 was meant to provide provincial autonomy in India. But it had also emergency provisions which put restrictions on the autonomy of provinces. It involved questions of relations between centre and provincial units. The Act empowered the centre to control and intervene in provincial matters if emergency arises due to war or internal disturbance, and make provision for carrying administration if the machinery of ministerial government failed to function. In times of emergency due to war or internal disturbances, Governor General was armed with power to make laws on all matters, even those in the provincial list. Governor General could declare emergency in provinces. Apart from Government of India Act 1935 and the Constitution of Germany also contributed to inclusion of emergency provisions in the Indian Constitution. The Governor General of India had in fact specific responsibility concerning peace and tranquility of India or any part thereof. Even he could act independently in the provincial government through the governor, who was also empowered to function in the respective provinces and was the main source of information of the Governor General. 112 Federalism and decentralization powers in practice. There are three kinds of emergency and each of them can be declared on different grounds. The three kinds of emergency are national emergency, state emergency and financial emergency. You will read about them below. 11.3. 1. National Emergency Art. 352. According to Article 352, a national emergency can be proclaimed in India in following situations: war, external aggression, internal disturbances or armed rebellion in whole of India or any part of it. The 44th Constitutional Amendment substituted the phrase, internal disturbance, with armed rebellion. The President can declare emergency after receiving a written communication about Cabinet's decision in favor of emergency, and after satisfying himself about prevalence of the situations just mentioned above. According to Articles 358 and 359, President has powers to suspend fundamental rights except in respect to Article 20 right to protection in respect to conviction for offences and Article 21 right to life and personal liberty. During national emergency, the Union government's powers extends to the jurisdiction of legislatures and executives in the states. It gives direction to the states the way executive power should be exercised. Art. 353. Parliament enjoys power to make laws which are not mentioned in the Union list. These also include matters listed in the state list. Art. 250. During the time of emergency, the President has constitutional power to modify the provisions of the Constitution relating to the allocation of financial resources between the Union and the states. Art. 253. Every proclamation of such emergency is required to be laid before each House of Parliament. If both Houses of Parliament do not approve the proclamation at the expiry of 1 month from the date of proclamation, it will cease to operate. If at the time of such proclamation, the House of the People has been dissolved or its dissolution takes place within 1 month after the proclamation, and if the resolution has been by before Council of States Rajya Sabha but has not been passed by the House of People Lok Sabha, the proclamation will cease to operate on the expiration of 30 days from the date when the House first met after it was reconstituted. However, the condition of expiration of 30 days does not apply if a resolution to this effect is passed by both Houses of Parliament. The proclamation, after being approved by both Houses of Parliament, will cease to exist after expiration of 6 months from the date of proclamation. It can be extended for another 6 months. A resolution for proclamation of emergency must be approved by a majority of total number of members of a House and not less than 2/3 of the members present in the House and voting. In addition, if the lower house passes a resolution disapproving the proclamation or its continuance, it shall be invalidated. Even if notice of a resolution signed by not less than 1/10 of the total members is given to the President or Lok Sabha Speaker, a special sitting of the House should be held within 14 days to discuss and consider it. The Indian Constitution may continue be effective for 6 months at a time unless revoked by the President earlier by a subsequent proclamation. Since independence, there were 3 instances of declaration of national emergency. First instance was during Indochina War from the 26th of October to the 10th of January 1968. Second was during Indo-Pak War, from the 3rd of December 1971 to the 21st of March 1977. And the third instance was during the 25th of June 1975 and terminated on the 21st of March 1977. The national emergency in first 2 instances was clamped due to wars with other countries. In the third instance, the reasons given by the central government were internal disturbances in the country. 11.3.2 State Emergency Act 356. State emergency is also often known as President's Rule. State emergency is imposed on failure of constitutional machinery in the states. All states in India except 2 newly created states, Chhattisgarh and Telangana, have been placed under state agency at different times. State emergency is imposed by the President if he is satisfied with the report of the Governor that there is breakdown of constitutional machinery in the state. President's Rule may be declared in the states on the following grounds. If the state legislature fails to elect a leader as chief minister. Breakdown of the coalition. If the elections are not conducted due to imminent reasons. And loss of majority in the assembly. Though state emergency is imposed by the president, it is the governor of the state who acts as representative of the president or the center. This is also called central rule in the states. The central rule in the states, except in Jammu and Kashmir, is called President Rule. In Jammu and Kashmir, the central rule is called Governor's Rule. The President through the Governor exercises legislative and executive powers. But his functions do not cover judiciary. 11.3.3 Financial Emergency Act 360. According to Article 360, financial emergency can be imposed when there is financial instability in India or any part of it. In India, financial emergency has not been imposed. If a situation arises for proclamation of financial emergency in India, it must be approved by the Parliament within 2 months of promulgation. In case the lower house is dissolved at the time of proclamation of financial emergency, it will cease to exist on expiry of 30 days from the date of its first meeting after its reconstitution. Under the situation of financial emergency, the President can reduce the salaries of all government officials, including Supreme Court and High Court judges. Even money bills and other bills under Article 207 passed by the state legislatures need to be submitted to the President for the approval under such circumstance. With respect to Jammu and Kashmir, as the state enjoys special status under Article 370, Indian Union have no power to promulgate financial emergency in Jammu Kashmir. 114